give it just a second to kick in.
Hear ye, hear ye, hear ye. The Supreme Court of Texas is now in session. All those with matters to present shall come forward to be heard. Pending before the court is cause number 20-0001, City of Balboa Bay versus Bluth, before Chief Justice Hecht, Justice Busby, Justice Guzman, Justice Boyd, Justice Blacklock, Justice Green, Chief Justice Lehrman, and Justice Cooper. Petitioner may begin upon instruction from the Chief Justice.
Well, we're happy to be here at the Texas Young Lawyers State Moot Court Competition. Over the years, it's been our pleasure to judge the final round of the competition every other year at the State Bar annual meeting. And we've never done it by Zoom or remotely, but we've never done a lot of things remotely until this pandemic has beset us, and we're learning how to do that. The court has had 5 arguments by Zoom and 7 conferences. So we're used to this format, and we hope it will give the contestants the opportunity to present their arguments. So we're ready to hear argument in City of Balboa Bay against Bluth. We're ready to hear from the petitioner.
Thank you, Your Honors. Can everyone hear me all right on Zoom?
Yes.
Mr. Chief Justice, Your Honors, may it please the court. My name is Blaine Hill, and I'm here along with my co-counsel, James Fryer, and together we represent the petitioner, the City of Balboa Bay. There are 4 issues before the court today. I'll be addressing the first 2 issues, which are the jurisdictional issues. First, whether the respondent's motion for en banc reconsideration was timely and proper, and second, whether the permissive appeal statute requires a substantive ruling. My co-counsel will be addressing the last 2 issues, which deal with whether the Solid Waste Disposal Act preempts the city's ordinance and the question of duty. At this time, I would like to request a 3-minute rebuttal.
That's fine.
Thank you. At some point, all cases must end and become final. And the question under the rules of appellate procedure is not whether the rules condone an unfair result, but whether they require one. Now, the procedural history of this case is especially important to the first 2 issues before the court today, issues 1 and 2, which I'll be addressing. Now, this case started out in the trial court with a denial of summary judgment, then went to the Court of Appeals on the permissive appeal statute. At the Court of Appeals level, the Court of Appeals reversed and rendered in favor of the city, granting summary judgment and dismissing the plaintiff's claims. The plaintiffs, now respondents, then filed a motion for extension of time to file both their motion for rehearing and their motion for en banc reconsideration. That was granted by the Court of Appeals. However, they filed only their motion for rehearing within that extension time. That motion for rehearing was denied by the Court of Appeals, and 15 days after the denial, the respondents filed their motion for en banc reconsideration. The en banc Court of Appeals vacated the Court of Appeals judgment and dismissed the appeal for want of jurisdiction. The city then petitioned this court for review, which this court granted on all 4 issues before the court today. Now, I'll be addressing 2 issues today. First, that the respondent's motion for en banc reconsideration was untimely and improper based on Rule of Appellate Procedure 49.5. And second, that the plain language of the permissive appeal statute does not require a substantive ruling. Going to my first point, which is that the en banc motion for reconsideration in this case was not proper under Rule of Appellate Procedure 49.5. Now, this first issue deals with whether the en banc Court of Appeals had jurisdiction and mainly hinges on the interpretation of the Rules of Appellate Procedure, specifically 2 words in Rule of Appellate Procedure 49.7. Now, the 2 rules in this case, 49.5 and 49.7, must be read together in order to give effect to the drafter's intent. Now, Texas Rule of Appellate Procedure 49.7 states that a party may, within 15 days after the Court of Appeals judgment or order, or when permitted, within 15 days after the Court of Appeals denial of the party's last timely filed motion, that they may file a motion for en banc reconsideration. Now, these words, when permitted, are important to give effect to the drafter's intent. They must refer to something. Now, before diving into Rule 49.5, it's important to note that these rules were revised in 2008. And in the comments to the revisions, it stated that these revisions were made to specifically address a motion for en banc reconsideration and to treat it as a motion for rehearing.
Let me interrupt you just for a second. You mentioned that the motion for extension of time, the 60-day motion, included a request for en banc as well as a panel rehearing. Is it your position that because they requested both at that time that they were required to also seek the motion for reconsideration within that time frame?
Partially, Your Honor. More position is that because they filed that motion for rehearing and the 2008 revisions required the motions for rehearing and en banc reconsideration to be treated the same, when they filed that second motion for rehearing, that it was not allowed under the rules. Thus, after the 2008 revisions, these two motions should be filed together, Your Honor. So, and sorry, Justice Busby, are you about to?
Wouldn't that make, I thought you were arguing the other side. Wouldn't that make your own petition untimely?
No, Your Honor, because this court in Vertberg v. Donner found that when a motion is untimely, it's treated as an implied motion for extension of time. So in this case, we would ask this court that that same rule be applied to the petition of review so that this court can look at this case on the merits and decide this interpretation of the rules of appellate procedure and whether the substantive ruling is required under the permissive appeal.
Is there any basis for filing a petition for review before the en banc Court of Appeals dismisses an appeal?
Your Honor,
that petition untimely?
No, Your Honor, we would, well, there are the rules for when to file a petition for review under Rule 53.7 does discuss the effects of that, Your Honor. But in this case, when the parties, at the time that that motion was filed, the parties had yet to discover that that motion wasn't proper, and thus to punish the parties and allow them to lose their ability to petition this court for review based on that, we would find that was unfair.
So and is it the procedural posture of this case then that distinguishes your arguably late filing?
Technically, yes, Your Honor. We would just ask this court to liberally construe the rules as they always have and allow that if it is considered a late filing, allow it to be considered an implied motion for extension of time. And the parties would be happy to then file that official motion for extension of time as this court has allowed in other cases. Now, the when permitted language most naturally refers to Rule 49.5. And Rule 49.5 deals when further motions for rehearing can be filed. And a further motion for rehearing can only be filed under three circumstances. And that is if the Court of Appeals, 1, modifies its judgment, 2, vacates and renders a new judgment, or issues a different opinion. Now, in this case, the Court of Appeals denied rehearing, and thus a further motion for rehearing was not proper or allowed under the rule.
Doesn't the Cruz case go the other way?
Yes, Your Honor, the Court of Appeals in Cruz did find that that did go the other way. However, we asked this court to find that instead this rule does apply to when permitted. To do otherwise would allow parties to endlessly file motions for en banc reconsideration. The respondent's position is that this rule doesn't apply to motions for en banc reconsideration. And if it doesn't apply, then there's no limit on how many times a party can file a motion for en banc reconsideration.
Counsel, I have a question.
Ms. Hill?
Oh, sorry, go ahead, Justice Boyd.
Thank you, Justice Cooper. Ms. Hill, I was wondering, the motion that was filed for the 60-day extension requested that extension for both the motion for rehearing and for the motion for reconsideration en banc, correct?
Yes, Your Honor.
And then the Court of Appeals issued an order granting that motion?
Yes, Your Honor. The extension for motion for time was granted for the 60 days.
Okay. What was the language of that order with regard to the motion for reconsideration en banc?
Your Honor, we don't have the exact order in the record. However, the record does state that the motion for extension of time was granted. Other than that, we have
as to both the motion for rehearing of the panel and the motion for reconsideration en banc?
Yes, presumably, Your Honor.
So what I'm wondering is if the Court of Appeals entered an order that gave the party 60 days to file a motion for reconsideration en banc, and the party failed to file that motion within 60 days, why doesn't that order resolve the issue here? They failed to do what the order said. Why do we even need to look to the deadlines and the rules when they failed to comply with the court's order?
Yes, Your Honor, and this court could certainly find that because they didn't file that within the time of the extension, that it was also untimely. However, the respondents are arguing that the plain language of Rule 49.7 allowed them to do what they did in this case, and therefore that's why we're looking at the interpretation and looking to the words when permitted in 49.7, Your Honor.
Counsel, let me take you to your permissive appeal issue.
Yes, Your Honor. Which brings me to the second point, which is that the plain language of the permissive appeal statute does not require a substantive ruling. Now, the permissive appeal statute is found in Texas Civil Practice and Remedies Code 51.014 subsection D. And the permissive appeal statute is an exception to the general rule that only final judgments are appealable, and allows the trial court to certify a case for interlocutory appeal if the order to be appealed involves a controlling question of law as to which there's substantial grounds for difference of opinion, and an immediate appeal from the order may materially advance the ultimate termination of litigation. Now, the plain language of the statute does not require the trial court, to make either a ruling or a substantive ruling. However,
Counsel, it requires an order. So why, if you're going to have an order that's being appealed from, why doesn't that have to be an order that decides the controlling question of law? Why isn't that a reading of the text that we should follow?
Yes, Your Honor. The statute requires an order, but it doesn't state that that order has to be a ruling on the controlling question of law, which the courts of appeals, when looking at this statute, have dismissed many cases for want of jurisdiction for the trial court not making a ruling on that controlling question of law. Is
it an order if it doesn't make a ruling? Is it an appealable order?
Yes, Your Honor. The permissive appeal statute is slightly different from the typical error analysis that goes into effect on final judgments, where, of course, a ruling is required in order for an appeal to occur. However,
take the interlocutory appeal statutes. Those require an order also. So why shouldn't we interpret this reference to order to mean the same thing that you would have if you had an appealable interlocutory order, say on a plea to the jurisdiction, or on an issue of personal jurisdiction special appearance? Something
yes,
like
Your Honor. I'm sorry, were you finished, Your Honor?
Go ahead.
Yes, Your Honor, because in this case, there was an order. The orders to be appealed in the statute, it doesn't require a specific wording in the order. The trial judge in this case had an order which granted permission for the parties to file that permissive appeal. And this court in Sabre Travel International found that the only thing needed to invoke the courts of appeals jurisdiction was that permission by the trial court. So following the plain language, that order can be present without the substantive ruling. And that's what's important here. The courts of appeals have looked into this statute and made a requirement that the legislature did not clearly require. There can still be an order. The order just doesn't need to be an order on a substantive ruling, Your Honors.
Counsel, I have a question.
Did the order in this case do anything other than authorize the permissive appeal?
No, Your Honor, the order it followed the language of the statute and authorized permissive appeal, Your Honor.
So the trigger event is that you have an order that is signed by the trial court saying you can appeal this. But if I'm reading Sabre International, the Court of Appeals still has discretion to deny the appeal. So why couldn't the Court of Appeals deny this based on the fact that the order itself doesn't specify what the controlling question of law is?
Yes, Your Honor. And to answer that question in parts, firstly, that this court found in Sabre International that even though the courts of appeals do have discretion, that they shouldn't use it. They should instead use the jurisdiction that the legislature has granted them whenever possible. And additionally, Your Honors, what the courts of appeals have been doing with the substantive ruling requirement is not that they're dismissing based on their discretion authorized in subsection F, but instead they're dismissing the case for want of jurisdiction because there's no substantive ruling and not based on their discretionary authority. And therefore, we would ask this court to find that the substantive ruling requirement is not in the plain language of the statute and therefore not required. And we ask this court to reverse the ruling of the en banc Court of Appeals and hold that that Court of Appeals judgment still stands. Thank you.
Any other questions? Thank you, Ms. Hill. We'll hear from the petitioner on the other two issues.
Rules of the competition require me to change the name on Zoom, so if you'll kindly bear with me just a moment. All right, and then one last technology check. I assume y'all can still hear me okay?
Can.
Very well. May it please the court, my name is James Fryer. I'll be speaking for the city on the third and fourth issues before the court today, whether the Solid Waste Disposal Act preempts the city of Balboa Bay's bag ban, and whether Officer Taylor owed a duty of care to Ms. Bluth. This court should hold that the city of Balboa Bay's ordinance is not preempted by the Solid Waste Disposal Act for one simple reason. The ordinance had nothing to do with solid waste.
Mr. Fryer, before you get too deep into this, I'm just wondering, I am correct, am I not, that the per curiam portion of the en banc Court of Appeals never reached either of the two issues you're about to address. Is that correct?
That is correct, Justice Boyd. They did not reach these issues.
That being the case, I'm just wondering why we should reach them when the Court of Appeals has not reached them at all. Why shouldn't we just decide the jurisdictional question and then, assuming the Court of Appeals should have reached the issues, send it back to the Court of Appeals for them to reach those issues and decide them in the first instance?
Your Honor, this court has the right to do just that. It could have not granted these issues the argument that we have today. They could have decided the jurisdictional issues, and those are dispositive. Instead, in the granting of this argument, this court did decide to take up the substantive issues for its own reasons. Presumably, it is something to do with having some judicial efficiency, understanding that we are going to be able to decide on potentially on the substance of these issues, so long as the jurisdictional questions come out, giving this court that ability to do so. But Your Honor is absolutely correct. There is no procedural requirement to reach the substance. If you find on the jurisdictional issues, that is dispositive, as it was at the en banc Court of Appeals. But to these substantive issues, the reason the Preemption Doctrine comes from the Texas Constitution. It comes from Article 11, Section 5A, and it's about power. It's about the power of the state legislature and how it is a monopoly over the power of local city ordinances. It's a bit like a Venn diagram. The state legislature, where it governs, occupies that space and monopolizes it, and cities are free to govern outside of that space, but they may not overlap. And so as the Laredo Merchants decision held, this court has already spoke to bag bans. They spoke to the way that the Solid Waste Disposal Act governs a local city's ability to ban bags. And this court held in that decision that even if there were multiple reasons for adopting a bag ban, such as in that Laredo case where they had aesthetics in their own mind and they had safety, they also were explicitly attempting to control solid waste. And that's where this case differs. This case differs because whereas the city of Laredo had identified a solid waste problem and adopted a bag ban to address it, the city of Balboa Bay did not have a solid waste problem and presumably did not adopt its bag ban to address it. Indeed, they did discuss solid waste repeatedly when deciding whether to adopt this bag ban.
Mr. Fryer, what would prevent all of the cities that have had their bag bans found not compliant with the statutory scheme from just changing their language and just deciding, well, this has nothing to do with solid waste? I mean, wouldn't that just be an end run around City of Laredo?
Yes, Your Honor. Pretext is always an issue when we're talking about preemption. Clever city attorneys may read this court's decisions on any preemption issue and attempt to avoid this court's preemption jurisprudence by doing just that. So the body that will govern against that happening is this court. But the case that we have before us today is not pretextual case. What we have before us today is a city seeking to beautify its space in its own judgment and in exercising its sovereign power, deciding that the actual use of plastic bags, not their discarding, not the litter they cause, not the potential sewer blockages that they cause, but their actual use was not aesthetically pleasing, and they adopted an ordinance for beautification. They adopted the same type of ordinance that cities adopt when they talk about trimming trees. When they talk about, having a couch that is sitting on the front yard of a house, when they talk about the facades of buildings, and that the ordinance may have solid waste implications does not mean that the city was improperly using its power when it adopted it. Take that couch example. That couch is solid waste, and it is aesthetically displeasing. Now, when the city ordinance says you can't have a rotten couch on your front yard, they are not treading on the Solid Waste Disposal Act because they're not governing in the solid waste arena. They're governing in the arena of aesthetics. And so even though you can have trash be affected by an ordinance, it doesn't mean that that ordinance is preempted because the legislature has spoken about trash.
Is there any overlap on that? And if there is, what does that do to the preemption argument?
The preemption argument relies on, Justice Guzman, it relies on the idea that a city is preempted when it is exercising power in an area where the state legislature has monopolized it. And so there can be overlap, as you suggest, in effect, but there can't be overlap in the exercise of power. And it is about that Venn diagram. And this is something that the Laredo Merchants case made very clear. If there is any overlap in the exercise of power where the state legislature has monopolized its ability to govern, the city may not govern. But as this court has held in DCCA Appeals Group versus the City of Houston, so long as the city is governing in a space that the state legislature has not yet spoken, it is free to do so. And this is the balance that the framers of the Texas Constitution endorsed. They want the state legislature to be prime and to be the monopoly on power. But if they haven't spoken in a particular area, this state also wants cities to be able to govern themselves as their local needs are met. So there is another remedy.
Excuse me. Does your argument really turn on whether or not this plastic bag was litter?
No, Your Honor. My argument turns on whether or not the city adopted its ordinance to govern solid waste or not. And we suggest—
Okay, then that it's not solid waste. Does it turn on that this was not solid waste?
Your Honor, a discarded plastic bag is undoubtedly solid waste. We're not contending that any otherwise. The Laredo Merchants decision makes that very clear. We're contending that the city wasn't governing solid waste. It was governing in the area of aesthetics. It was governing because the proponents of this bill and the council, as it adopted this bill, they identified solid waste as a potential problem and rejected it as an actual problem in the city of Balboa Bay, and they passed the ordinance anyway. And they passed the ordinance.
Is this just totally a textual read in terms of, you're saying this was done for aesthetics as opposed to solid waste control? So is this just that we look at the statute and if it says, it's not for solid waste that it's fine, or is there some sort of fact determination that needs to be made? And if so, who makes that?
Yes, Justice Cooper, the Supreme Court makes that determination, or any court in a pretext analysis preemption analysis makes that analysis. And there is a requirement to look past the simple stated language of any ordinance to the actual effects implicit by that ordinance. That's was held by this court in Lower Colorado River Authority versus the City of St. Marcus. So we can tell in this case that it was not about solid waste based on the record, based on the fact that Lucille Bluth, who brought this case to the forefront, didn't think the city had a solid waste problem, based on the council voting down the proposed finding of a solid waste problem, based on the inconclusive study on page 6 of the record, coming to the conclusion that there was no solid waste problem.
Mr. Fryer, let me, I'm sorry, Justice Guzman.
No, go ahead, Chief Justice.
Let me take you to the negligence issue.
Yes, sir. Thank you. This court should hold that Officer Taylor owed no duty of care to Miss Bluth for 2 reasons. First, the actual injury to Miss Bluth was unforeseeable. And second, to hold a new duty under these facts and circumstances would put a chilling effect on officers when they use their lights and sirens. Now, this court laid out how to determine when a new duty is in place in its decisions in Pagillon and Humble Sand and Gravel. And it says that a court must look to the social, political, and economic circumstances of the fact of the case and then evaluate, among other things, the risk inherent based on the pleadings, the foreseeability of the injuries, and any possible chilling effect it might have on future plaintiffs. Now, foreseeability is the reason why there should not be a new duty. The city is convinced that Officer Taylor's behavior is potentially blameworthy. There is some risk in using the siren for personal use, and we're not going to contend that point. Foreseeability, however, is where there is no duty that arises, and foreseeability has its analog in the traditional negligence tort of proximate cause, and that word plays 2 roles. It plays both the foreseeability of the injury that occurs, such as a siren startles somebody and they fall, that's foreseeable. It also plays a role in talking about causation. And similar to the Fourth Amendment context, if you have potentially blameworthy conduct over here, but there are many other links in that causal chain before you get to injury, at some point it no longer is reasonable to hold that blameworthy conduct liable for the.
So excuse me, are you saying that there were intervening events that could have caused it? How long was the period of time between the siren and the injury?
Yes, Your Honor. We are saying that the causal chain was attenuated. The amount of time between the siren and the injury is one thing we do look at it in the causal chain. So to answer your question, the time was very short. However, the actual occurrence of this injury was also bizarre. This is reminiscent of a famous case called Pulsgraph, where a bomb went off in a train station, causing a scale to fall on a woman's foot. And Justice Cardoza, then Judge Cardoza, found in that case that the circumstances were simply too attenuated. There was potentially blameworthy, at least a jury question, blameworthy conduct, but there was a bomb, there was a Rube Goldberg effect that ended up causing Miss Pulsgraph's injury. Here we have a similar circumstance. You had the siren being activated. You had Miss Bluth having a bag underfoot, that improperly discarded bag, which may also have some blameworthy elements to it. You have her failing to catch herself. You have her actually sustaining serious injuries from a body height fall, which is somewhat unlikely as well. And so that series of events attenuates the taint of his potentially blameworthy actions in activating his siren for his own personal reasons to this actual injury. And why
isn't this just all for the jury to decide?
Well, this court has found in the Pagillon case and in Humble Sand and in other cases over the last 20 years that the court has a role as a gatekeeper in determining duty. And it does have a role with risk, which sounds a lot like breach, and foreseeability, which sounds a lot like cause, in determining that some court cases just should not go to a jury as a matter of law. And we do this duty analysis as endorsed by this court. And so for these reasons, we hope that this court will find that the city's bag ban was not preempted and that Officer Taylor owed no duty. Thank you.
Any other questions? Thank you, Mr. Fryer. We'll hear from the respondent.
Mr. Chief Justice, and may it please the court. My name is Brooke Bolin, and alongside my co-counsel, Joseph Reynolds, I represent the respondents in this case, Lucille and Lindsay Bluth. Of the 4 issues before the court today, I will be addressing the first 2, dealing with the timeliness of the Bluth motion for en banc reconsideration and the 15th Court of Appeals' lack of jurisdiction as to the city's permissive appeal. Later, you'll hear from Mr. Reynolds regarding the preemption of Balboa Bay's bag ban and Officer Taylor's duty of care. To my first issue, there are 2 reasons that the Bluth motion for en banc reconsideration was timely. First, the motion was permitted within the meaning of Texas Rule of Appellate Procedure 49.7. And second, the 15th Court of Appeals still had plenary power at the time the Bluths filed their motion, and so it was proper for the court to take it up. Now, before I get to my first point, I will say that I feel a bit odd at arguing this issue because, of course, Chief Justice Hecht, Justice Green, you were both on the court in 2008 at the time that the when permitted language was amended into Rule 49. So I do not presume to tell you what you intended at the time that that language was added. But what I do know is that in the first draft of the amendment to Rule 49 that came out of the Supreme Court Advisory Committee, as reflected in this court's Order 08-9017 in March of 2008, that when permitted language was not present. It didn't come in until later in the final draft of the amendment to Rule 49 in August of 2008 and in the court's final order. So based on what I know about how Texas court rules are made, Chief Justice Hecht, I've read your article of that same title. So based on that, I'm making the inference that that when permitted language came in sometime during the public comment period. Beyond that, there is no record as to why it was added. So again, far be it for me to tell the court what the court was thinking when it was adding that language, but here's our interpretation. When permitted most likely refers to another subsection of Rule 49, that's Rule 49.11. That rule happened to be added in the same 2008 amendment as the when permitted language. And what the rule says is that a motion for en banc reconsideration may not be filed after a party has already filed a petition for review with this court. So keeping that in mind, that that was added at the same time as the when permitted language, it makes sense that the court may have been thinking about the Rule 4911 when it inserted when permitted into the rule. Now, another reason that that reading of when permitted makes sense is because Rule 4911 specifically references motions for en banc reconsideration, unlike Rule 49.5. And further, 4911 restricts when a motion for en banc reconsideration may be filed. So it makes sense with that restrictive language that it would not at certain times be permitted under 49.7. That is the interpretation that the Dallas Court of Appeals took in the case Cruz versus Ghani last year, when it looked at a case that was procedurally very similar to this one. In that case also, the party had a motion for rehearing denied, took the 15 days to file a motion for en banc reconsideration.
So are you conceding that the city's petition was timely?
Yes, Your Honor, it is our position that the petition was timely, because otherwise we'd have to argue that our own motion for en banc reconsideration was untimely. We wouldn't want to do that because that would render the en banc decision invalid, leave us with the panel decision, which of course was not in our favor. So we do concede that their petition for review was timely under our reading of 53.7. But it matters that the court look at this issue to determine what is required in the appellate courts as far as what when permitted means for the filing of these motions. And now to speak to the petitioner's argument that it's a better reading of when permitted to look to 49.5, there's a few reasons that that is not a better reading. The first of which is that that rule does not mention motions for en banc reconsideration, despite the fact that there are 4 subparts to Rule 49 that mention both motions for rehearing and motions for en banc reconsideration. Those subparts were all added are all amended in the 2008 amendments to add motions for en banc reconsideration. So we see that the drafters, when they wanted a rule to apply to both motions, they said so. Rule 49.5 was not one of those rules in which they said so.
But the drafters also said in the comments that Rule 49 is revised to treat a motion for en banc reconsideration as a motion for rehearing. So why shouldn't we follow that direction and treat motion for rehearing in 49.5 as including a motion for en banc reconsideration?
Yes, Justice Busby. Well, that's because the comment was an explanation of the changes that were made in 2008 and not a directive. The comment explained why there had been provisions added for motions for en banc reconsideration. Admittedly, several of them do mirror the provisions as to motions for rehearing, but 49.5 is a rule that solely applies to motions for rehearing because it goes a step further than any of the rules that apply to motions for en banc reconsideration in requiring those three prerequisites that petitioner pointed out.
But why wouldn't that make sense as a matter of orderly procedure? Why would we want to allow parties to build delay into the Court of Appeals process by being able to wait to file a motion for en banc reconsideration after the court denies the motion for panel rehearing? Why shouldn't they file them both at the same time as they do in the federal system? And it seems like we could accomplish that by treating the words "a further motion for rehearing" in Rule 49.5 as including a motion for en banc reconsideration, as the comments suggest.
Well, Your Honor, the reason that it would not be good from an efficiency standpoint to require parties to file both motions at the same time is because then the full court is going to have many more en banc motions before it than it would otherwise, especially on things that could easily be resolved by the panel at panel rehearing.
Well, actually, the way it works for most courts of appeals internally is the panel looks at the motion for en banc anyway. So it really wouldn't be more burdensome from an efficiency standpoint for the courts of appeals to have them both filed at the same time.
Well, Your Honor, that said, it would still promote the confusion among litigants about whether they should be filing these motions at the same time, and it would take some of that power away from the panel in these situations. And now, respondent isn't asking here for a third bite at the apple in filing their motion for en banc reconsideration after their panel rehearing was denied. We're asking for a bite at a totally different fruit. The full court has not considered this case, just the panel has. And for that reason, as a matter of policy, it makes sense to allow these motions to be filed sequentially. And
if we accept your reading of Rule 49.7 to say that when permitted means that so long as the Court of Appeals grants leave, there can be, another motion for en banc reconsideration filed. Is there any sort of substantive limitation that says, okay, this is the fourth one, this is the fifth one, now that's enough? What would stop people or litigants from filing a motion like this every 15 days, basically?
Justice Cooper, there is a practical limitation, and that also is in Rule 49.11. Of course, that rule says that if a party wants to file a petition for review, they can't also have a motion for en banc reconsideration out there. So practically speaking, parties aren't going to want to bang their head against the wall by filing motions for en banc reconsideration over and over again, when instead they could take the next step and file a petition for review with this court. So
let me pose a hypothetical question to you. Let's say that it may not be the litigant's idea to go to the Texas Supreme Court. Let's say that there may be an election coming and they want to kind of drag things out to see if there's going to be a new set of judges to make this argument for. And so in that case, would there be anything that would prevent somebody from filing these sort of motions for leave until they get a new shot at a new shot at whatever?
Your Honor, admittedly, in the rules as drafted, no, but there would still presumably be some discretion among the court in that situation to not take up the same motion over and over again. And for that reason, we argue that this court should hold that the Bluth motion for en banc reconsideration was timely. And with that, I'll move to the second issue I'm discussing today, which is that the city's permissive appeal did not confer jurisdiction on the 15th Court of Appeals in this case. And that's for two reasons. First, the permissive order at the trial level did not identify the controlling questions of law in this case as required by Texas Rule of Civil Procedure 168. And second, the order also made no substantive rulings on either question of law. And so any opinion from the appellate court would have been an advisory opinion. Now, to that first point, petitioner walked the court through the permissive appeal statute in Texas Civil Practice and Remedies Code 51.014D. But that statute is supplemented by a procedural rule that offers a few more specifics as to what a permissive order needs to look like. Procedural Rule 168 specifically requires that the order identify the controlling questions of law. Now, as reflected on page 6 of the record, that did not happen here. And so for that reason alone, the appeal was jurisdictionally insufficient. That's been the position of at least two of the intermediate appellate courts, the San Antonio Court of Appeals and the Austin Court of Appeals, that even just failing to identify the controlling questions of law under the rule fails to confer jurisdiction upon the court.
Could the order be amended to allow that, as it can be to add permission? I mean, why should we treat this as a jurisdictional impediment rather than a defect of following the rules that can be cured?
Your Honor, it could be amended, but the reason that it's a jurisdictional impediment is because the procedural rule just says out loud what is implicit in the statute. And it's that you can't have an order involving a controlling question of law without identifying what the question of law actually is. And that's especially true because, as this court pointed out in Valley Baptist Medical Center versus Gonzalez, Article 2 of the Texas Constitution does not authorize state courts to issue advisory opinions. And so reading the permissive appeal statute with that in mind, it would be a reading that would render the statute unconstitutional if it allowed judges to issue permissive orders without making a substantive ruling on either issue of law, as what happened in this case.
I thought that was your second argument. I was asking about the first argument, that they didn't identify a controlling question and why that was not, but why we should or shouldn't treat that one as jurisdictional. I understand your argument about why you need to make a ruling as a constitutional matter, but just describing the issue in the identifying the controlling question as to which there's a difference of opinion, why would that piece of it be jurisdictional?
Your Honor, simply because the rule says something explicitly that is implicit in the statute itself, that it would need to be identified in the order in order for the order to involve a question of law as the statute requires. And that was the reasoning of those two courts of appeals that held they did not have jurisdiction in cases where the order was deficient in that way. But to the substantive ruling requirement, 11 of the 15 courts of appeals in this state have found that there should be a substantive ruling required in these permissive appeals, precisely for the reason that otherwise the court would be issuing an advisory opinion, which is not permitted by the Texas Constitution. And now that's not asking the trial court to jump through hoops or perform extensive legal analysis. All that would have needed to happen here was for the trial court order to state either yes or no, the bag ban is preempted, or yes or no, Officer Taylor has a duty. And that would have been sufficient to confer jurisdiction onto the intermediate appellate court here. Of course, according to the record at page 6, that did not happen. And looking to the trial judge's comments on pages 5 and 6, he even alluded to the summary judgment motions being denied due to a fact issue. So it really is unclear in this case what the controlling questions of law are, and any ruling on those is completely absent. Now, because the Bluth motion for en banc reconsideration was timely filed, and because the 15th Court of Appeals lacked jurisdiction to hear the city's permissive appeals, we ask that this court affirm the 15th Court of Appeals. Thank you.
Any other questions? Thank you, Ms. Boland. We'll hear from respondents on the other issues.
Mr. Chief Justice, and may it please the court. My name is Joseph Reynolds, and as my co-counsel, Ms. Boland, mentioned, I'll be addressing the second two issues before the court today as to why the Solid Waste Disposal Act preempts the Balboa Bay bag ban and why Officer Taylor owed a duty to Lucille Bluth. Your Honors, to the preemption issue, there are two reasons that the Balboa bag ban is preempted by the Solid Waste Disposal Act. First, the ban on plastic bags manages solid waste in the exact same way that the already preempted Laredo ban did. And second, despite the Balboa Ordinance's stated purpose, both its origin and background are intimately related with the management of solid waste, and we can use effect to inform upon the purpose of a stated ordinance. Now, this court simplified the elements of preemption for the Solid Waste Disposal Act in its 2018 decision of City of Laredo versus Laredo Merchants Association. There it held that first, the ordinance is preempted if the act is for solid waste management purpose. Second, that it restricts or prohibits the use or sale of a container or package. And third, in a manner not authorized by state law. But to determine whether this ordinance is preempted, we're already 2/3 of the way there, because we know single-use plastic bags are contained within the definition of the Solid Waste Disposal Act, and there are no current laws on the books that allow cities to regulate packages or containers for solid waste management purposes. So this issue really just hinges on whether there is a solid waste management purpose in the Balboa Ordinance. And based on the background and the effect that we can look to determine purpose, we know that it is. In fact, if we compare this to the ordinance that the City of Laredo enacted, we find many similarities. In fact, prior to passing the Laredo Ordinance, the city conducted extensive studies on the environmental and solid waste implications that single-use plastic bags have on the environment.
Is that preempted, just conducting studies?
Absolutely not, Your Honor, but we can use that information leading up to the passage of the ordinance to help inform upon effect and inform upon the purpose. And by no means are we saying this is dispositive, but we can certainly look to this information to find the appropriate purpose. And this isn't a novel.
We also look at the fact that one draft of the ordinance had the solid waste purpose in there, and then it was taken out.
That's exactly right, Your Honor. We can look to that as well to determine what the city council was thinking leading up to the passage of the ordinance. And admittedly, they were on paper rejected by the city council as not being an issue, but just the very fact that one of the council members decided to conduct a third-party study demonstrates that at least some people believe that there was a solid waste management problem. It's also important that we don't have to have a problem to have a purpose. Admittedly, solid waste management purpose isn't defined under the Solid Waste Disposal Act, but solid waste and management are. Solid waste.
Mr. Reynolds, the bags don't become waste until they're discarded. Couldn't you just have a blanket ban on bags, for other reasons, aesthetic reasons, without even addressing whether or not they become a problem once they're discarded? And, why isn't that permissible?
Well, Your Honor, that was one of the exact same arguments made by the City of Laredo during oral arguments, that because it was a consumer product and not yet trash, it couldn't fall within the scope of solid waste management. But in Chief Justice Peck's opinion for the court, he notes that it still includes consumer goods, because if it really only contained or included containers like dumpsters or already trash, well, it wouldn't make sense to only restrict the use or prohibit the sale or use of trash. That statute would effectively have no effect at preempting any state ordinance. And we are.
Do we give any credence at all to the fact that if the city council says we're not doing this for a waste management purpose, we're doing it for another purpose, do we give that textual finding any purpose at all, or what weight does that carry?
Absolutely, Your Honor. We can still consider the explicit purpose, but as outlined by this court's decision in Southern Crushed Concrete versus the City of Houston, we can also look a little bit further beyond that. There, it was dealing with an ordinance that limited the location of a concrete crushing plant to a shortened distance, and they said this was only for land use. But as this court expressed in its opinion, the reason why it was related to land use was because of the preempted air quality portion. The only reason why land use values would go down as a result of the concrete crushing plant entering the neighborhood is because of its air quality implications. And that's the same thing we have here, because the bottom line is this bag ban prohibits the sale of distribution of single-use plastic bags at the point of sale, at the point of generation. And what that's doing is reducing litter. And admittedly, while it's not litter at the point of sale, we all know that by the very nature of disposable single-use plastic bags, they're going to become litter. And that implication helps expand the overall scope of that this ordinance has within the meaning of solid waste disposal.
Is there anything that a city could say or do to demonstrate a purpose other than solid waste that would save its ordinance from preemption? Or is it your position that all plastic bag bans are preempted regardless of what the city says about its purpose?
So under our interpretation, all plastic bag bans would be preempted because of its prominent effect that it has on solid waste management. And this was also a concern expressed by Chief Justice Hecht during oral arguments of Southern crushed concrete, where he asked if the city could pass a purpose that just stated, well, the residents don't like it, and if that was enough. And that's exactly what the city of Balboa Bay has done here. They say that the city doesn't like single-use plastic bags. They don't want to look at them. But the reason they don't want to look at them is because they're trash. They're in a place that they shouldn't be, and they're solid waste that the residents don't like. Now,
normally you'd worry about a city being able to manipulate the preemption outcome with that kind of a pretextual explanation. But here you've got a statute that the statute that you're claiming preempts the ordinance itself speaks in terms of the city's purpose, which seems to be a subjective inquiry.
Ordinarily it is, Your Honor, but again, under the principles of Southern crushed concrete, we can help look to the effect to inform upon the purpose. And again, we aren't saying that effect is dispositive, but when the effect is so pronounced, we can't divorce that from the actual purpose of the act. And we also understand that there are severe environmental implications that single-use plastic bags have, as Justice Guzman's concurrence demonstrates, urging the legislature to take steps to help prevent these. But
Counsel, let me ask you. So you're saying purpose and effect are dispositive in determining whether this is preempted. So let's say City Council decides to pass something not, for solid waste management purposes, but they say we have the subjective intent of doing this for aesthetics, and that the effect doesn't really have an effect on whether people are using plastic bags because in this city people just use paper bags. So you have a subjective intent, and then the purpose, it's sort of ineffective. Is that still preempted under your analysis?
Well, Your Honor, to be clear, we are not arguing that effect is dispositive. Merely purpose and effect is used to inform on that. And if the city, to make sure I understand your question correctly, you're asking if the purpose is for solid waste, but the effect is not?
No, if the city says the purpose is not for solid waste, and then the effect is that objectively it has no sort of effect on the use of plastic bags or not.
Then absolutely not, Your Honor. It wouldn't be preempted because, one, it's not regulating a container or a package, and two, it's not doing it for solid waste management purposes. And even if we look to the effect, that wouldn't inform or suggest that there's an intimate relationship between those single-use plastic or the solid waste purpose, essentially. Now, moreover, if we take the city's argument today, we're essentially providing a prescription to help avoid preemption by just using these magic words to be able to say it's for an alternative purpose. And that's the exact same issue that the Office of the Attorney General had during oral arguments of Laredo Merchant, expressing that it would effectively give no value to the state law if they're able to just use these one-off words to help avoid it. And because if we look to the effect of the bag ban in Balboa Bay, that it restricts or reduces source reduction of single-use plastic bags at the point of sale, and that is solid waste management, it should be preempted by the Solid Waste Disposal Act. Now, shifting to my fourth point, or the fourth point before the court regarding Officer Taylor's duty, there are also two reasons why Officer Taylor owed a duty of ordinary care when operating his lights and sirens to Lucille Bluth. First, all persons generally have an ordinary duty of care with those they come in contact with, and that includes police officers. And second, even if this court disagrees and holds that there's an exception for police officers, there should be a special duty of care imposed on police officers' operations of lights and sirens. Now, as a preliminary matter, we
not limited by foreseeability considerations.
Absolutely, Your Honor. If it's this court's contention that the ordinary duty doesn't.
We're not making a contention. We're just trying to understand your argument.
Yes, Your Honor. So just to work through the ordinary duty of care, it's our position that it encompasses police officers' everyday actions dealing with lights and sirens. So in the same manner that officers use their firearms in a reasonable way, are required to use their handcuffs, pepper spray, or any other police instrumentality in a reasonable manner, we think that same type of duty should apply to lights and sirens, or already does under that ordinary duty of care.
Mr. Reynolds, if a police officer is using his lights, he or she should foresee that a woman's going to trip on a bag?
Absolutely not, Your Honor. That's not our contention today. That is an element of foreseeability, but that foreseeability is more towards the element of breach, not establishing the legal duty. As this court expressed in 2017 in Pagillon versus ExxonMobil, we can look to foreseeability to determine whether a special duty applies. But that foreseeability is much more broad. It just has to be that a general danger exists from the defendant's conduct, not that a specific sequence of events have happened. So we can effectively, for the purpose of duty, take the plastic bag out of the equation and just look to whether there's foreseeable harm from officers deploying their lights and sirens.
Well,
And
isn't it a little bit different? You're in a parking lot, you're not speeding down the road, no one's really moving around. To that point that you just made, I'm just not following your argument.
Well, Your Honor, it's our contention that there's actually a higher foreseeability that people will become distracted or startled in a parking lot than on the highway. And the reason for that is because police lights and sirens are statutorily required to be able to be heard from 500 feet away. And this translates to roughly 120 decibels, which is 32 times the average pain threshold of a human being's ear and 20 decibels below what will traditionally rupture a human being's ear. Now,
And what's the magnitude of harm there at the Buc-ee's parking lot? Everybody just sort of milling around, getting a drink and using the facilities.
Well, here they became distracted and somebody tripped and fell as a result of that distraction. And again, that's going more towards the causation issue, not the duty issue. But it's certainly foreseeable by the very nature of lights and sirens that are designed to attract attention to the police officer's vehicle so that they can safely make their way through traffic, that distraction is going to is a potential risk. And this type of risk has already been somewhat acknowledged by the Texas legislature by providing a provision in the Texas Transportation Code that reduces the duty of care when responding to emergency situations, because they acknowledge the risk associated with deploying lights and sirens, but it's outweighed by the benefit of responding quickly to an emergency situation. Now, the special duty that
surely the risk could be too attenuated. When do you think it would be too attenuated?
Absolutely, Your Honor.
And 3 blocks away, if she'd been on the other side of the store, or what?
Absolutely, Your Honor. If, for example, 3 blocks away could be too attenuated, but that's not the issue we're dealing with here today, because that's dealing more with causation, not the existence of a duty.
Yeah, but you want us to draw a line as a matter of law, and I wonder how we do that.
Well, Your Honor, all we're asking for today is that police officers use their lights and sirens reasonably. It's not going to overburden police officers. They're still going to be able to respond to emergencies in a timely manner because it's for a good reason. They can still use it for police objectives like directing traffic or alerting of traffic conditions because it's for a good reason. All we're asking is to curtail unnecessary usage of police lights and sirens. And there's no burden on society or even a diminished social utility as a result of that, because all this is going to do is discourage inappropriate use of these lights and sirens. Furthermore, if we backtrack to some of those factors that this court considered in Pagillon, the likelihood of the injury occurring within the parking lot is also certainly foreseeable and high when compared against that social utility or minimal social utility. Because in tight quarters, much closer to the police officer's vehicle than one would be on, say, a highway, enclosed in a vehicle while the police officer is approaching, that likelihood of startling people is substantially higher. And we know from page 11 of the record that everybody in the parking lot was startled as a result of the officer's lights and sirens. Now, Your Honors, because the Balboa Bay bag ban enters the realm of solid waste management, and because Officer Taylor owed a duty to Lucille Bluth, we ask that the trial court's decisions denying the motions for summary judgment be affirmed. Thank you.
Any other questions? Thank you, Mr. Reynolds. Ms. Hill, you have 3 minutes, I think, for rebuttal.
Just to check, Your Honors, can you all hear me okay?
Yes.
May it please the court. I would like to address a few things on rebuttal. First, the respondent's argument about Rule 168 and its requirement that the trial court place in the state in the order the controlling questions of law. Now, Rule 168 is found in the Texas Rule of Civil Procedure. And in the Texas Rules of Civil Procedure, Rule 1, which states the objective of the rules, states that the rules are meant to be construed liberally for a just and efficient equitable way. And we ask this court to construe that rule that it's not necessarily a dismissal for want of jurisdiction under the permissive appeal statute solely because the judge does not put in the order the controlling question of law. We ask this court to make clear that when the judge certifies this case for permissive appeal under the permissive appeal statute, that is all it takes to trigger jurisdiction under the statute. And additionally, the respondent's reading of Laredo and the Preemption Doctrine is too broad. It would have that anything that might someday touch on solid waste disposal be preempted by the Solid Waste Disposal Act. In this case, the city was governing in the space of aesthetics and safety, and not in the space of solid waste disposal. And therefore, we'd ask this court to find that based on the plain reasons that the city gave for this bag ban, that it was not preempted under the Solid Waste Disposal Act. Additionally, Justice Hecht, you're absolutely correct. The risk in this case is just too attenuated from the harm. There are too many steps in between the conduct here and the actual injury in this case. And that's why we asked this court to find that there is no duty, because there was just too much that happened in between here that was not foreseeable to Officer Taylor. And for all those reasons, we ask this court to reverse the ruling of the en banc Court of Appeals and find that the Court of Appeals judgment dismissing the plaintiff's claims and granting summary judgment still stands. Thank you.
Any other questions? Thank you, Ms. Hill. The case is submitted. And now I think we'll excuse counsel while we evaluate the case.
We will actually excuse the judges to a separate breakout room. This Zoom call will remain live and streaming. So we also ask that the competitors leave their microphones and their cameras turned off until the judges return. I have not actually been talking, so I don't know why there was a message that I was talking. Just wanted to let you know that you didn't miss any pertinent information. We should have the competitors back in here soon for critique. All right, Chief Justice Hecht, I think we will let you determine how the critiques come through. Oh, you're on mute. There we go.
Now I'm unmuted. Wonderful job. Congratulations to all four of you. Usually we take a few minutes to comment on your arguments. And Justice Guzman, you may have to duck out at some point. Is that right or not?
That's correct. I'm in another Zoom.
Yep. So why don't you go first?
Well, just congratulations to all of you on your success thus far. From my perspective, you did a really fantastic job engaging with the justices and responding to the questions, really listening to the questions. And I know that you will have much success in your future careers. I thought every single one of you was just terrific, and it's a pleasure to have been asked to judge the competition. Thank you, Chief Justice Hecht.
Thank you so much.
I really appreciate that.
Justice Busby?
Well, thank you, Chief, and congratulations from me as well to all of you. When I was on the TYLA board, I was on this committee that organized the competition, so it's always a treat for me to come back. And I have to say, as an appellate advocate, this is a challenging format for any advocate and very new. And I thought you all handled it very well, and it's something that we're all learning to deal with. So congratulations on that as well. And if I spent my time giving you comments on what a great job you did on all the things you did, we'd be here all afternoon. So I'll just make a couple of constructive suggestions, maybe one for each of you. Ms. Hill, I was a little bit confused on the first issue and which side of that you were arguing and how you were getting to the timeliness. And I think maybe shortening your opening would have helped a little bit with that, but I thought you did a very nice job on the second issue, and that was very clear. Let's see, Mr. Fryer, I thought I knew that you were representing the city, but sometimes you referred to the city as they. You might refer to your client as we or us, just to be sure that the judges are there with you on who you're representing. I knew that, but when you said they, I thought, well, is this for the city or not? It made me question where we were, but I think you did a nice job on both issues, and a good use of names and many great things in your argument as well. Ms. Boland, I wouldn't be quite so apologetic about telling us what we were thinking. I think you used up a little too much time on that. Just come out with your view of, you can mention it once, but I'd just go on into your argument after that. Thought you had a nice transition to the second issue and explaining how that broke down. And Mr. Reynolds, I thought both parts of your argument were very clear. It took me a little while to catch up with where you were on foreseeability as a part of duty versus foreseeability as a part of breach, but then you came around and explained that a little bit further, and I understood where you were going on that. So great job to all of you, and thanks for the opportunity. It was a pleasure.
Thank you so much for the notes. I really appreciate it.
Thank you.
Thank you.
Thank you.
Justice Blacklock?
Well, I just wanted, you all did a great job. You really did. You all deserve to be in the finals. I agree with Justice Busby's comments. I don't think we're all going to have necessarily much to add to that, because he took a lot of the good constructive comments that I won't repeat. But the one thing that I noticed at the very end, and Ms. Hill, you spoke twice, and so that's twice as much opportunity for me to notice something. But the rebuttal is really a great time to be responsive in a very targeted way to particular things that were said by the other side, which are very fresh in the court's mind, and you kind of want to be writing down all right, he said X, he said Y, how am I going to hit that? What were his strongest points in his time, and can I knock those down in this couple of minutes that I've got for rebuttal, as opposed to more of a restatement of your position, which is not the best use of your time in a rebuttal. I had the same comment for Ms. Bolin on the sort of familiarity with the court and the tenure of the justices, and talking about what the intent was behind the rule change. That sort of, we're trying to look at this objectively based on objective factors, and that's sort of an approach. It didn't seem to work very well to me. I thought you all did a great job. You know the case well. It's a very, very strange case. One global comment for everybody is when you have a case like this with lots of ins and outs, and it helps to understand that the judge is looking at dozens and dozens of cases. You've just got your one case, and so a little more road mapping, a little more explanation of the big picture, rather than just get straight into what do the words "when permitted" mean. Back up and sort of set the stage to make sure that everybody listening to you is understanding why your arguments about what those words mean matter to the case. But you all really did a great job in terms of demeanor and style, and I enjoyed judging you.
Thank you so much. Very appreciated.
Thank you.
Thank you.
Thank you.
Justice Boyd.
Thank you, Chief, and I echo what the others have said about how great all four of you did. I started experiencing some connectivity issues when Justice Blacklock was just now speaking. I don't know if that was on his end or my end, but if you're having trouble hearing me, just wave or holler and I'll realize something's going on. But what I always like to do is just give one quick positive and one quick suggestion to each one of you. More on your style and approach than certainly on the substance. So I'll just do that very quickly. Ms. Hill, I found you to be very clear and concise and easy to listen to. I thought you used your hands really well. The overall demeanor I thought was excellent. You did something that I don't see many people do often, and that is when you wanted to read from your notes, you actually picked up the notes and showed us you were reading from them. And I've never seen that before, but I thought that was very effective. It was clear you were nervous, and that's just something you'll fix in time. You said improper instead of improper and little things like that, but that's definitely forgivable. That's just one of those things that you'll get more comfortable with. I thought you did a great job. Mr. Fryer, I thought you were particularly very calm and natural, and came across more than anyone else as just very conversational. Like this is just something you know and want to talk about. And I find that to be particularly beneficial and useful, because we are just trying to have a conversation about these things. I found that to be very effective. I will say you run the risk when you have that approach or style of being a little tedious or boring. And so you want to go ahead and let a little bit of emotion or passion or expression come out. But I found your very conversational style to be very effective.
Thank you so much.
Ms. Bolin, I thought you particularly had very good expressions with your face and hands as you were communicating. That really kept me watching you and paying attention to you. Something that I did not, the chief mentioned, I think we had 5 or 6 or 7, I don't remember how many real case oral arguments by Zoom. And the one thing I realized today, and even looking back, I think is true, is if you look at your screen right now, you see all of us with shoulder and head shots. but the four of you way back. And I think if we had all this to do over again, I'd really recommend each one of you be up there as a shoulder and headshot as you're speaking to us, because it really, I first noticed it with Miss Hill, but I think with Miss Bolin, what it did was it caused you to do maybe what I'm doing now, which is screaming a little bit. Occasionally it came across like you were screaming out at the camera over on the other side of the room. And that wasn't, I don't mean that so much as a negative, as just as much what we're all learning what to do with these remote arguments. I think my recommendation going forward would be for advocates to get up there with their head and shoulders and just talk to us. Mr. Reynolds, you were extremely knowledgeable, and that came across in the way that you answered the questions. Completely comfortable, I thought was excellent. I particularly liked the way that you asked Justice Cooper if you correctly understood his question. I thought that was very effective. You came across as a little bit performance oriented, just a little bit more on the performing side than the conversational side, but that's stylistic. You'll settle into your perfect style as you continue doing this. So congratulations to all of you, and it was an honor to get to watch all four of you.
Thank you.
Thank you so much.
Justice Lerman.
Well, I just want to congratulate all four of you. You all have done such a wonderful job, and you certainly deserve to be here. And on top of that, making it to this point, doing it in this format is just amazing to me. We don't know what we're doing, and we have heard several rounds of oral argument, and you all did just excellent in view of the fact that you couldn't have had too much to watch to get experience from, because we haven't had very many ourselves, and we don't really know what we're doing. It's the blind leading the blind here, for as far as we're concerned. So I can't add much to what my colleagues have said. I agree with all of their statements. You all have done just a wonderful job. You have so much to be proud of. I always, we do this every other year, and I always feel so bad because one team is going to, be the quote winner, and the other, and I hope all four of you know that no matter what happens, you're all winners. And you've just done an excellent job, better than some of the advocates in our court, actually. And so please know that that's very sincere, and I know you have wonderful futures ahead of you. So congratulations.
Thank you so much. Appreciate that.
Thank you.
Thank you.
Justice Green.
Well, not Justice Lerman, but some of my colleagues can be very harsh. I don't agree with that. I think y'all were spectacular. Brooke, hello, how are you? Good to see you.
Hi, good. How are you?
I'm sure y'all all are aware that Brooke was hired by me last year as a law clerk for this coming year. And just to allay everyone's concerns, I have not voted in this competition just for that reason. I wanted to participate and be an observer to all of this, but I just think it wouldn't be fair to the perceptions of that. But I thought all four of you were just terrific, and we go through these exercises each time that we do this, and all these compliments and criticisms are out there. But I'll tell you what, y'all are well prepared to appear before us and any other court, for that matter, because of the skills that you displayed and the knowledge of the cases and the 125 decibel police thing. I mean, who knew that, who did that kind of research? At any rate, we enjoyed the presentation for all of you. You're excellent, and we would welcome you to the court at any time. Thanks for being here.
Thank you so much.
Thank you.
Thank you.
Thank you.
Yeah, and I'll just echo what everybody else has said. We always think this when we get to the Moot Court finals, what sterling instruction you've had, how well you've done, and how good the future of the bar looks with people like you coming into our ranks and arguing cases. So you've got a lot to look forward to. These are strange times we live in, and very difficult times. One of the hardest things I think of presenting argument in a situation like this is that there's no majesty of the courtroom. There's no, the aura is not there. The kind of ambiance that brings solemnity to the proceeding. And despite all these fake pictures behind us, it's just not the same. But the good side of it is that you can really connect very well, very directly with the judges and vice versa. And that is something that we'll have to see how that develops over time. But the bar and the bench are all over the country are trying to get used to this because it's going to be happening more. And you'll have a leg up on them. The only other thing I would say is particularly in the Supreme Court, you ought to give the court some idea of what difference any of this makes. So, of course, there's a lot of importance to preemption and what it means and how governments interact, and then the whole negligence issue is very tricky, particularly when it involves law enforcement. I think a couple of us have said we were a little confused about the positions. I think Ms. Boland conceded that the city's petition was timely, and I didn't know what position you would take on that. But it needs, those kinds of things need a little explanation so that the court fully understands the case. But it was all good, and you're all a credit to your schools, and we want to know which schools those are. But first, so that it'll be on the up and up, I'll have to tell you who the winner of the round is. And the winner of this final round is the respondent. So congratulations to Ms. Boland and Mr. Reynolds, and congratulations to Ms. Hill and Mr. Fryer for a great round.
Thank you so much.
Thank
Congratulations.
You. Congratulations.
Thank
you all.
you. Good
It was a
round,
great
guys.
round.
Now, what schools?
Texas Tech.
And we're Baylor.
Baylor.
Good. Great.
Yeah. I appreciate it. Thank you so much.
Congratulations.
Thank you all so much. We would ask that you guys stay on just for 1 minute so each of the teams can take a picture with the panel. As is our tradition, it's a little bit different, but it'll be one for the memory books. So I guess we'll ask Team 2 can go first with their picture. Team 6 will turn off their cameras, and the rest of us will turn off ours as well.
I bet you Justice Johnson, the former justice, has got his guns up right now.
Yep. Yeah, he'll be proud.
Yes, he will.
All right, we're gonna take a screenshot here on a count of 3. All right, so smile big, and 3, 2, and 1. I'm gonna do one more. 3, 2, 1.
Okay, and then Team 6 can come up on the screen, and Team 2 can go on their screen off. Okay.
All right, we'll do 3, 2, and 1. One more. 3, 2, 1. All right.
Thank you all very, very much.
We really appreciate it.
Yes.
Mr. Cooper, if you wanted to give feedback to the competitors while the
I'm sorry.
No, it's totally fine.
sorry.
I don't have anything to add. I'm not an actual judge. I'm just one on Zoom today.
I'm sorry.
No, it's totally fine. It's totally fine. You know, I just want to echo everything that everyone said. This was excellent argument. I know that these are sort of issues of first impression, or that there's not a lot of case law on this. And I thought just substantively, everybody did a really good job kind of handling that. I thought all the presentations were great. I'm the chief staff attorney at the 8th Court of Appeals, and I can tell you that, you all are better than some of the attorneys that I've seen have come up for oral arguments. So you guys have very bright futures. I wish you all well. And yeah, consider joining TYLA.
Chief.
Yes.
Chief.
Yes.
Speaking of TYLA, if I can just congratulate Michael and Kaylin and Sarah and Ashley and everyone from TYLA, because they faced quite a challenge figuring out how to do this under these circumstances, and you guys have pulled it off. And I just want to congratulate you on an excellent job that you can all be very proud of for pulling this off.
Absolutely.
Here, here.
Yeah, absolutely. Agree.
Next year. Bye-bye.
Thank you very much.
Thank you.
Thank you, everyone.
Yep.